The opinion of the court number 02102, Lawrence against Texas, will be announced by Justice Kennedy.
The question before the court is the validity of a Texas statute making it a crime for two persons of the same sex to engage in certain intimate sexual conduct. In Houston, Texas, police officers were dispatched to a private residence in response to a reported weapons disturbance. The right of the police to enter does not seem to have been questioned at any stage in the case. The police entered the apartment where one of the petitioners, Joseph Geddes Lawrence, resided. The officers observed Lawrence and another man, Tyrone Gardner, engaging in a sexual act. Gardner is also one of the petitioners here. Lawrence and Gardner were arrested, held in custody overnight, and charged under the Texas criminal statute. The statute punishes certain sexual conduct when committed by persons of the same sex. The petitioners were convicted, and they challenged their convictions under the Due Process and Equal Protection Clauses of the Constitution. The Court of Appeals for the Texas 14th District affirmed the conviction. They had an in-bank hearing, and it was a divided court. The majority in the state court considered Bowers versus Hardwick, a decision issued by our court in 1986 to control the federal due process aspect of this dispute. We granted certiorari to consider the constitutional claims presented, including the question whether Bowers versus Hardwick should be overruled. We conclude this case should be resolved by determining whether the petitioners were free as adults to engage in this private conduct in the exercise of their liberty under the Due Process Clause of the 14th Amendment. And for this inquiry, we deem it necessary to revisit this court's holding in Bowers. Bowers versus Hardwick had some factual similarities to this case. There, too, a police officer observed the petitioner in his own bedroom engaging in intimate sexual conduct with another man. And as in the instant case, the defendants in Bowers were adults at the time of the alleged offense, and their conduct was consensual. The Bowers court rejected the petitioner's claims under the Due Process Clause. The Bowers court began its discussion as follows. It said, "The issue presented is whether the federal Constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time." That statement, in our view, discloses Bowers' failure to appreciate the extent of the liberty at stake. To say the issue in Bowers was simply the right to engage in certain sexual conduct demeans the claim put forward, just as it would demean a married couple were it to be said that marriage is simply about the right to have sexual intercourse. The laws involved in Bowers, and here are, to be sure, statutes that do prohibit a particular sexual act. Their penalties and purposes, though, have more far-reaching consequences, touching upon the most private human conduct, sexual behavior, and in the most private of places, the home. The statutes seek to control a personal relationship that is within the liberty of persons to choose without being punished as criminals. Now, in academic writings, some of which are referred to in the opinions, and in many of the amicus briefs filed in this case, there are criticisms of the historical premises that were relied upon by the majority and in the concurring opinions in Bowers. We need not enter this debate to reach a definitive historical judgment. It should be noted, however, that there is no long-standing history in this country of laws directed at homosexual conduct as a distinct matter. Laws prohibiting sodomy do not seem to have been enforced against consenting adults acting in private. A substantial number of prosecutions for which there are records were for predatory acts against those who could not or did not consent, as in the case of a minor. The history relied upon in Bowers is more complex than the majority and concurring opinions in that case indicate. The historical premises are not without doubt. At the very least, they are overstated. Now, it must be acknowledged that the court in Bowers was making the broader point that for centuries there have been powerful voices to condemn homosexual conduct as immoral. The condemnation has been shaped by religious beliefs, conceptions of right and acceptable behavior, and respect for the traditional family. For many persons, these are not trivial concerns, but profound and deep convictions accepted as ethical and moral principles to which they aspire and which thus determine the course of their lives. These considerations do not answer the question before us, however. The issue is whether the majority may use the power of the state to enforce those views on the whole society. Our obligation is to define the liberty of all, not to mandate our own moral code. In all events, we think that our laws and traditions in the past half-century are of most relevance here. These show an emerging awareness that liberty gives substantial protection to adult persons in deciding how to conduct their private lives in matters pertaining to sex. We discuss in the opinion, as part of that emerging awareness, the legislative determinations in some of the states to repeal laws prohibiting private consensual conduct between adults. And we cite the same policy and provisions of the model penal code promulgated by the American Law Institute. Many of these changes already had taken place when Bowers was decided. Then Chief Justice Berger was one of the 5 justices in the Bowers majority. He filed a separate opinion, and there he made sweeping references to the history of Western civilization and to Christian moral and ethical standards. That, however, did not take account of authorities pointing in an opposite direction, including the decision of the European Court of Human Rights in a case called Dudgeon versus United Kingdom. That decision, with facts like Bowers in the instant case, held that laws prescribing this sort of conduct are invalid under the European Convention on Human Rights. Now, in today's opinion, we discuss some of the cases decided before Bowers. These precedents, including Griswold versus Connecticut, Eisenstadt versus Baird, Roe versus Wade, and Carey versus Population Services, all limited the government's authority to enter the most private aspect of the lives of individuals. The holding of Bowers is inconsistent with the teaching of these cases. 2 principal cases decided after Bowers cast its holding into even further doubt. These are Planned Parenthood versus Casey and Romer versus Evans. Romer versus Evans was a case decided under the Equal Protection Clause. There may be a tenable argument that the guarantee of equal protection renders the Texas statute unconstitutional, but it is our view that the instant case requires us to address whether Bowers itself has continuing validity. We conclude the rationale of Bowers does not withstand careful analysis. Bowers was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers versus Hardwick should be, and now is, overruled. The present case does not involve minors. It does not involve persons who might be injured or coerced, or who are situated in relationships where consent might not easily be refused. It does not involve public conduct or prostitution. It does not involve whether the government must give formal recognition to any relationship that homosexual persons seek to enter. The case does involve 2 adults who, with full and mutual consent from each other, engaged in sexual practices common to a homosexual lifestyle. The petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty, under the Due Process Clause, gives them the full right to engage in their conduct without intervention of the government. It is the promise of the Constitution that there is a realm of personal liberty which the government may not enter. Had those who drew and ratified the Due Process Clauses of the Fifth Amendment or the 14th Amendment known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom. The judgment of the Court of Appeals for the Texas 14th District is reversed. Justice O'Connor has filed an opinion concurring in the judgment. Justice Scalia has filed a dissenting opinion in which the Chief Justice and Justice Thomas join. Justice Thomas has also filed a separate dissenting opinion.